people arrive from the waiting room. A few more people just dropping in. Okay. Thank you all so much for joining. My name is Katie. I'm just helping out with the tech today. So I will hand over to Hazel and Romina in just a moment, but just to let you all know that the chat function might be disabled. If you have got any questions throughout, we do have a Q&A option. Please feel free to drop them into the Q&A box and we can deal with those at the end of the webinar. Otherwise, over to you.
Right, thank you, Katie. Thanks for that introduction and thank you for helping us today. I'm Hazel Manktelow. I'm a mediator and been a solicitor for many years. I've been mediating for nearly 15 years. I work for a firm called Family Law Partners and Choice Family Mediation. I do all things mediation based, which is meeting with families. I meet children. I'm a practice consultant, so I help support other mediators. In the time that I've been mediating, I have developed and adapted how I offer and structure mediation to suit different families. I've worked out that the traditional way we may have been offering mediation isn't always right for everyone. Romina and I are going to talk to you today about the different ways that mediation can take place to give it the best prospect of success for you and your family. So can I have the next slide, Katie, please? So if you've attended any other presentations this week, you will already have a good idea of what mediation is. In a nutshell, it's a process to help families reach agreement following the breakdown of their relationship and ideally to help them avoid contested court proceedings. It's there to try and get a conversation going between the family. I believe that what makes mediation such a powerful process is that it's partly its voluntary nature. No one can be made to come to mediation. You choose to come to it. Also, you as the clients in the mediation process are in control of the decision making within that process. Nobody can tell you what to do. So yes, the fact that mediation is voluntary is why I think it works. Clients choose to use it. You invest in it. You therefore work hard within it to try and find a resolution. At the beginning of the mediation process, we'll talk to clients about the other process options available. And again, it's knowing what the other choices are that sometimes makes it feel like mediation is the best choice and why people stick at it. The legal option of going to court or using arbitration will result in decisions being imposed upon you if you can't agree a way forward as part of that process. The court system doesn't have the time and the capacity to look at the nuances of your family and all your priorities. Mediation allows you to do that, to decide what needs to be discussed. You'll set an agenda at the beginning of it. Mediation will probably primarily be used for deciding arrangements for the children or division of finances. However, it has the flexibility to cover any matters that you want it to do so. I mean, some examples could be that come up quite regularly. Living arrangements, and how to give each other space in the house while you're living in the same property and going through a separation. There's a lot of people that can't afford to move out and have to remain in the house, which makes it quite difficult, and we can talk about ways to manage that. You can have detailed discussions about the division of the contents of the home. Doing that in other processes can be quite an expensive option. Mediation makes it more cost effective. We can talk about the family pets if we need to. And in nearly every mediation that I conduct, we'll talk about communication and how to improve that. We can talk about parenting meetings or boundaries for sending messages. We can talk about apps such as our Family Wizard that Katie's here from today. Can I have the next slide, please, Katie? Although we can make mediation flexible and change the process, there are some core principles that we need to ensure that we follow. I've already talked about how you come to mediation voluntarily. You can't be made to take part in it. That's an absolute key principle. The conversations in mediation are confidential. They shouldn't be shared with anyone other than professional advisors, such as solicitors or financial advisors. The discussions, if mediation ever broke down, would never be able to be shared with the court, because it gives you to give you that freedom to have that opportunity to discuss options, consider ideas. It's for you to make the decisions, as I've already said. It's not for the mediator to tell you what to do. We're there to support you. We can give you ideas. We can talk about option generating. We can give you examples of what we've seen other people do, but ultimately it's your decision. And probably one of the main principles we all know, that it's our job as a mediator is to be impartial, and we act in an even-handed way. We can't provide legal advice, but we can provide information about the law. Katie, can I have the next slide, please? So traditional family mediation, when I did my training about 15 years ago, this is how we mainly conducted mediation. There would be 1 or 2 mediators, and the meeting at that stage was likely to be in person. Now it could be online, and you would be together, both of you, with the mediator in the same room, whether that's virtual or in person. And all the conversations, once you've got into your first joint meeting, would take place with the parties and the mediator being present. There's no private conversations. It all takes place together. And that's how most mediations are run, but that doesn't work for everybody. Next slide, Katie. So when that sitting in the same room together with the mediator may not be the best option for you, or the most appropriate option, we can look at other ways of dealing with things. And that's what Romina and I are going to talk to you about in more detail now. Next slide, Katie. So a choice for mediation, or one option, is something called hybrid or integrated mediation. It uses a combination of family mediation and civil mediation techniques. Civil mediation runs in quite a different way to family mediation, and we use those processes or those different options and combine them. Hybrid mediation is often conducted on a shuttle basis. Romina is going to talk to you a little bit more in her part of the presentation about what shuttle mediation is, but essentially it's where the mediator moves between the two of you, rather than you necessarily being in the same room. The main difference to traditional family mediation with regard to hybrid mediation is that the mediator can hold confidences for periods of time, not necessarily forever, but for periods of time. What that can mean is that, for example, you might have your bottom line for settlement as to how far you'd be prepared to go, but you don't want the other person to know that yet. But you can let the mediator know what you might be prepared to move to, or some concessions you might be prepared to make. And that can help the mediator in their conversations with the other person. The other sorts of confidences that might be held is you might, if you're dealing with a particular person, the other person's got particular characteristics that are perhaps a little more difficult to manage, then you can talk to the mediator about the best way to share information or to provide proposals to that person. And that's a confidence that can be kept within the hybrid mediation process. We commonly think within the mediation world that hybrid mediation or integrated mediation means that solicitors will be coming into the mediation process. That's certainly something that can happen, but that can happen in both hybrid and traditional mediation. It doesn't just have to be within hybrid that solicitors are there. Can we go to the next slide, Katie, please? So I'll talk a little bit more about solicitors coming into mediation. They would sign the agreement to mediate, which you will also sign if you're coming into mediation. That sets out the rules of mediation, some of those core principles that we talked about. So the solicitors are bound by those principles as well. They're bound by the confidentiality of it. Solicitors might come in where there are complicated legal issues. Perhaps there might be very high value assets and it needs a bit more management. They might also come in when there's a difficult relationship between the parties, such as domestic abuse, or perhaps one person feeling that the other person knows much more about the finances than the other, and they feel a little bit on a less even ground to the other person. They might be a particularly vulnerable person that just feels that having a solicitor there to support them is helpful. The solicitor's role in the mediation is to support you. It's not to advocate for you. It's not to put forward what you want to say in the mediation process. They'll help you with putting that together and formulating it and reminding you. But ultimately, it's for you to tell the mediator what is important to you, what your priorities are, what you would like to seek. Because hybrid mediation will often be conducted on a shuttle basis, where the mediator might not be with you and your solicitor all the time, that also gives you that opportunity to have legal advice that's confidential while you're in that meeting. This can be really helpful for moving you forward with regard to finding a way, a resolution, a set of proposals, because you don't have to leave the mediation room and then go and get advice from the solicitor and then come back perhaps a few weeks later. You can have that there and then. So solicitors attending mediation can be a really useful tool to bring matters forward and help you with reaching that outcome. Next slide, please, Katie. So child inclusive mediation. I always think the title of this is pretty awful. It makes it sound like the child's coming to sit in the room with parents while you two have a bit of an argument about what's going on with that child. That's not what it is at all. It's a confidential meeting for the child. Child inclusive mediation is probably my favourite part of mediating. It's such a privilege to meet the children. They've always got something entertaining to tell and share, and quite insightful as to the situation. Many parents might think the children don't know a lot about what's going on, but those confidential meetings soon give a better indication that the child probably knows more than we all realise. Child inclusive mediation is usually for children aged 10 and over. Younger children can be invited if the parents think it's appropriate, or younger siblings might come along. There's not really an upper age limit, probably late teens. I have seen as old as 19. It depends on the family and what would be helpful. As parents, you have to give your consent to the children meeting with the mediator. You sign a particular agreement, and in that agreement, you're saying that you're not going to prep the children for the meeting. You're also signing to say that you're not going to ask the children what they talked about in the meeting. Of course, the children can share with you what they've talked about if they want to. It's entirely up to them. But the children are told that you have signed up to say that you're not going to ask questions, and they quite enjoy that, and having that ability to say to their parents that you can't ask them questions about what they talked about. They like coming along to the meetings because they're curious. They want to know who it is mum and dad are seeing and why and what's going on. But they do ultimately have the choice as to whether or not they come to meet with the mediator, even if the parents have agreed. The children don't have to come to the meeting. They might feel it's not right for them. But as I said, most of them do come if for no other reason, curiosity, and quite often the sweets that they'll have available. So always an incentive. The conversation between the child and the mediator is confidential. The child chooses what information is shared with the parents by the mediator. Quite often we'll agree messages that are going to come back. The parents aren't in the meeting with the mediator and the child. Usually they'll wait in the reception area outside. So they're available but not able to overhear. It's not about the child making decisions about how much time they spend with mum and dad. That is absolutely the parents' decision. What it is about is giving them a voice, and it's giving them the opportunity to speak to somebody who's talking to both mum and dad, who's impartial, and that they can just share what life is like for them now mum and dad are separated. The feedback can vary. Some children just give some really positive messages that they're really happy with what's going on, or they're happy for mum and dad to decide. Others might talk about how they don't like being used to pass messages, or that maybe their tummy hurts when mummy and daddy meet because they get worried that there's going to be an argument. Others might have some very clear ideas of time they want to spend with each parent. The feedback session, which will be on a separate day with the parents, is one of the most powerful mediation sessions I think there is, that you'll hear your child's voice in the messages that are fed back from the mediator. It can be emotional, it can be difficult to hear sometimes, not because the messages are necessarily particularly negative, but just because you're hearing your child's voice through someone else. But it's really powerful with regard to helping you to make decisions about what's best for your children. It enables the focus to come back to the children, perhaps rather than what your discussions have been between the two parents. In addition, you might hear some things from your children that you hadn't previously realised they were thinking or considering, and it's an incredibly useful part of mediation when you've got to talk about child arrangements. I think I'll now hand over to Romina. I think she's going to take over from there.
Thank you so much, Hazel. Next slide, please, Katie. So my name's Romina Cameron, and I am a fully accredited mediator. I have been registered with the Family Mediation Council since 2017. I'm also a PPC, which means I train and support other mediators who are aspiring to be accredited themselves. And I'm the founder of Art Mediation, so my own practice in mediation services. I'm going to just talk to you a little bit more about shuttle mediation. I know Hazel mentioned it earlier on, just so that people are aware of exactly how it takes place. Probably the most common question that I get asked is, can I even be in the mediation process if there's been domestic abuse? And I think this is where shuttle mediation comes into it quite nicely. So we mentioned before that clients are not in the same room. So back in the day when I was training, shuttle mediation would have been physically in a place and you would be shuttling literally between two separate rooms. And nowadays, the majority of mediation takes place online. So we're able to still offer shuttle mediation by simply creating meeting rooms and separating the clients into their own room. And I think shuttle is so important because it actually drills into one of the core principles that Hazel mentioned earlier on in mediation, which is impartiality. So because we are not all in the same room, whether it be virtual or physical, it's really important as the mediator, when we are taking the messages and the information that one client is providing and wanting to share to the other, that we are keeping ourselves totally impartial and passing on that information back and forth. And what I say to clients is there are instances, of course, and I'm sure you can all imagine a few, where I am not going to say exactly word for word what one client has said to another. And there are some obvious reasons for that. So I will say in some instances, I may reframe and take out certain language and put perhaps a softer delivery. But the message that they want us to essentially get across will always get across to the other client. So in terms of going back to situations where there's been domestic abuse, in the initial meeting with a client, we are assessing whether mediation is suitable. We assess it in that first meeting, and really we should be assessing it the entire way through once they're engaged in the process. And we will be asking things about domestic abuse, whether it's been present and what's taken place. And based on the information that the client's willing to share, we together will decide whether mediation feels as if it's the right process for them. And in instances where there's been domestic abuse and where clients have come and said, I do want to mediate, I really do, I feel this is the right process, but I just don't want to hear their voice, I just don't want to see them, but this is kind of what I think I would like from the agreement. Shuttle works really well because they don't have to see them, they don't have to hear them, and we can hopefully get them to reach an agreement on the issues that they're currently struggling with. So it can be used in cases where there's been domestic abuse, but it can also be used where there's high conflict. I've had mediations where they've been perfectly fine for the first session. We've all been in one room. We get to the second session and something triggers them. And actually it makes sense, rather than the entire process coming to a stop, to just separate them. So we've then switched to shuttle mediation just to kind of calm things down. So there are lots of examples where mediators can then use shuttle to help them help clients reach a final proposals. It allows people to have a voice. So I had a client just the other week who said to me, I feel really challenged when I'm in front of him. I just can't say what I've just said to you. I just know I won't get my words out. You know, he talks over me, and I just don't think I can have a voice in this process. So as the mediator, at that point, you're thinking, well, rather than saying mediation is not for you, we can explain shuttle and how it can benefit them and how they can still have a voice, but without all of the feelings associated with actually having to hear the other person speaking to them. And there might be certain words and triggers that makes them really uncomfortable. Next slide, please, Katie. Third-party neutrals. Okay, so there are situations where in mediation you have the mediator, sometimes two, as Hazel pointed out. We call that co-mediation, and we have the two parties. But there are also instances where, when the two parties are collaborating on what they feel is the right sort of settlement for them, they need a third-party neutral. And this is someone that often provides an expert opinion on a particular aspect of their situation. So they could be asked to provide advice on pension sharing options, maintenance need, mortgage capacities. I mean, they're just some of the sort of key ones that often come up, but it could be any of those. It's often a financial advisor, and they do both have to agree. And the neutral, similar to us mediators, you know, remembering that we have to be impartial. We are not allowed to give advice. We are not allowed to give legal advice. All we can do is sort of guide and suggest and signpost. They will be there working for both parties, and hopefully providing information that they then need to help with their proposals and division of assets. Next slide, please, Katie. So an ENE, which stands for an early neutral evaluation, it's a separate dispute resolution, but can still be used within the mediation practice. And it's a bit similar to, as I was just talking about, the third party neutral, but instead of them attending mediation, they would be providing that information or giving an opinion on what they think would be a realistic outcome. So often clients, and again, this is more of a collaborative approach because both parties have to agree, but there is an instance where both parties can say, you know, we're not far off reaching agreement. We just need to understand what the reality is of what we're both possibly proposing. And so a summary of the client's positions, along with any of the background that's important, is then provided. Often this can be solicitors, and they might work as a barrister or a judge or an arbitrator, and essentially they would just provide a sort of holistic view that they believe the law would approach in terms of the client's settlement. Next slide, please, Katie. Thank you. So family consultants in mediation. So often these tend to be individuals from a more therapeutic background. They specialise with working in couples. And I actually had a client just the other day ask me whether they could still mediate even though they were going to therapy. So they were going to therapy regarding the breakdown of their marriage, and they just weren't sure if they could do both. And my answer was, mediation is a voluntary process, so it's about both parties feeling that they can make suggestions and proposals and be heard, but ultimately reach an agreement that feels right for them. And if you are working with a family consultant who is helping you on that journey, then it can really be quite supportive to the mediation process. Something that we talk about in mediation quite a bit. I mean, we don't just talk about division of assets, and we don't just talk about children arrangements. We talk about communication. We talk about what's difficult for them right now, you know, why they find themselves in mediation. And sometimes we have to unpick some of that to help them move forward, to help them look forward as to what their life could be like, what are they trying to achieve. And we talk about the loss cycle, because often there'll be one party who made the decision to end the relationship some time ago. And so emotionally, they're a little bit further along than the other party. And this can make mediating them quite challenge, because they are looking at proposals, they are looking at the future, they are looking at having everything organised. They're already dreaming where they're going to put the plant pot in their new home. The other party is completely overwhelmed. They were not expecting it. They're still grieving the end of their relationship. They are not ready to look at division of assets. They're not ready to go and consult with a mortgage advisor to see if they can get a new mortgage. They don't want to do any of it. So they're a bit stuck. So actually having that therapy sometimes can really support what they are dealing with emotionally. So we can use family consultants in the mediation process, outside of the process, alongside mediation. Sometimes they can also attend in shuttle, and they can sit with each party individually and swap over. So they'll be doing some of the shuttling as well. Next slide, please, Katie. Other third parties. So again, this goes back to one of our core principles as mediators, which is that what we provide, you know, in our space is confidential. There are exceptions which break the confidentiality, and we let our clients know what those are. But in terms of third parties, they're bound by those same rules. So if you are wanting to bring someone along, whether it's a family member or a work colleague for support, or a friend, that's absolutely fine, as long as both parties agree to that individual also being present. And sometimes this can be very helpful. There are scenarios where there are people that really want to use mediation. Both parties want to use mediation. I had a case a few years ago where one particular client was extremely unwell, and as part of her symptoms, she would just struggle to retain information. And often she would come to the session almost needing a recap, because she would have already forgotten by the time we started the session what we were going to be discussing. So she had a third party who was a good friend of both of them, who also ran her own company. And she was just brilliant in terms of supporting the conversation, bringing her back to what she was trying to achieve. They're not there to make decisions for that person. They're not there to interfere in that way. They are there to sort of support that one party that would otherwise probably not be able to be part of mediation. Next slide, please, Katie. So other ways to flex the process. So the brilliant thing about mediation is that it is very, very flexible. And by that, what do we mean? We can completely arrange the timetable, not just our own, but around clients' needs. So, you know, if clients have a particular working pattern, or if they need to, you know, finish mediating by a set time because they have school pickup, we work around that. You know, in terms of it being extremely flexible, it allows for modern day life. It's something that we can just jump on, be prepared for, get online. We do still offer it face to face, although it's not as popular as it once was when I was first training. So it's an extremely flexible process in that respect. Families can return as their children get older, and I think this is a really interesting one. So the wonderful thing about mediation is you can come back to it. So if you found it to be a positive experience, and I never say happy because it's not, and I hope that's not because of the mediators, it's just not a nice thing to have to do. No one joins a session excited, they join apprehensive and nervous. And I say, hopefully by the end of it, you'll feel like a weight's been slightly lifted, and often they do. And the thing about mediation is you can come back. So what I often tell parents in particular who are trying to co-parent is today it feels really challenging and you've hit a bump, and mediation's helped you get over it. You've both done the work to hopefully come up with something that's sustainable, but you might need to come back. And that's okay, because as your child grows, as your circumstances change, there may be scenarios where you struggle again, whether it's communication, whether it's new partners. That's often a really big topic that often pops up in mediation. It's just about navigating those challenging times. And so mediation is that process that you can just come back into. You know it worked, you know how effective it was, and you can say, these are our new issues, and I know it worked last time, but this time it's like this. And I've had clients come back to mediation many years later, and they're able again to avoid court. And court, I always say, is, you know, it's not something that people look forward to. The wonderful thing about court is that no matter what, there is an end in sight. But if it can be avoided, then clients will try to avoid it. And mediation, often being able to come back and talk about things again, can support that. Mediation doesn't have to be between husband and wife, or, you know, two people that cohabited. It can be a mother and her daughter. It can be siblings. It can be friends. It can be work colleagues. It really is. Are you having a dispute and are you struggling to work through it? Then think about mediation. And the fact of the matter is, the process can take into consideration various needs that clients have, whether that's disabilities or particular family dynamics that we need to consider, whether there's been domestic abuse. We're able to talk about all of these things and together assess if mediation is the right process. Next slide, please. So the first meeting is called a MIAM, and I often say to clients, it stands for Mediation, Information and Assessment Meeting. And I don't know why they give it so many words, but the fact that we've shortened it makes it a bit easier, except most people don't know what they say. They'll phone up and say, I know I need a MIAM, but they're not really sure what it means. So that is simply your initial meeting with an accredited mediator. And I know I keep saying accredited, you can often meet with trainee mediators as well, but if you do need a court form signing, or if it's a legal aid assessment, then you would still need an accredited mediator to oversee that. So the initial meeting is with a mediator, and we go through all of the things that we've just talked about. So we'll talk about impartiality, confidentiality, that it's voluntary. We will ask about whether there's been any form of domestic abuse. We'll try and understand a little bit about how they got where they are today and what they're trying to achieve. And we'll try and assess what kind of case is it going to be. Is it an all issues mediation, which means finances and children arrangements, or is it just children? As I've said, the meeting will be confidential. There are those two exceptions, one of which is any safeguarding concerns that are disclosed in that initial meeting. We have a duty of care to report those. So any safeguarding concerns against a child, and we would have to do that. So we make it very clear from the get-go what the expectation is. And the other is if a client decides to disclose any fraudulent activity, money laundering, then again, we have to disclose it as well. So they're able then to share, as I say, as much as you feel comfortable sharing with a total stranger about the most personal situation in your life. It is, for me, the most important part in a way. It's where, as the mediator, you are assessing how you can help them, whether this is right for them, what their issues are, where they are not seeing eye to eye, where you think the conflict may rise in a situation, in a session. So it gives us then an insight into what we can expect. Now, having said that, despite years of doing this and all my efforts of thinking where I think a session's going to go, there will be the clients that really surprise me. And there's still, you know, they've been a challenge, but it helps me as a mediator always be ready to expect the unexpected. So that initial meeting provides us with a base and understanding. We're assessing if it's right for them, and at the same time, it's kind of for them that introduction into whether this feels like it could be the right process or not. Next slide, please. Oh, we're at the end. So I don't know if we have any questions that people have asked. I think, Katie, you're managing questions.
Yes, so we've had one in the Q&A here that says, how do you recommend a client proceed when they are experiencing trauma triggered either from domestic abuse, even with a shuttle type of mediation?
I'll take that one, Hazel, and then you can come in if you like. So I think it's also okay to say there are the instances where mediation is not suitable. So despite us assessing whether it's right or not and clients wanting to do it, there are times where as a mediator you have to call it and say, I just don't think that this is the right forum for kind of getting out of it what you need. We have clients that are experiencing, you know, terrible trauma or have done so. What we need to do as mediators is make sure, and you know, we're limited in terms of safety and things like that, but what we can try to do is understand whether mediation between those two parties would make a situation worse. So we don't want to really be doing that. We don't want anybody to feel as if they mediate, they are then in a position where the other party gets increasingly more violent or decides to do something that they weren't expecting. So in that instance, we would then say, look, I don't feel that mediation's right, and we would talk about the alternatives. I don't know, Hazel, did you want to come in on that?
I think an important part of the MIAM is exploring what it would feel like to be in mediation, and that is a large part of the session. So I'll be talking to the person about how it might feel to, whether you're in the same physical room, whether you'd be shuttling, because even shuttling is not doable for some people. It is too traumatic, because if we come back and we use a certain phrase that is triggering for the other person, we may not know it's a trigger. So we really do explore right at the beginning the best way to do this. And the other thing that I'll always tell people that come into mediation is that at any stage, whether you're in the room or on screen, you can just wave your hand and say, I need a break, and we will break you out, or we will spend time, or in the building, go and have a walk, go and make a cup of tea, whatever it may be to help you get through that. Then we've got options, but mediation isn't going to be right for everybody, but it's right for more people than perhaps may initially seem on the face of it.
We have another question here that says, do you think the gender of the mediator matters? Is the process male and female friendly? And is there more of a need for male mediators in the industry?
Yes, is the answer. There's a need for more males.
Yeah.
Shall I start, Ramina?
Yeah, go for it. Yeah.
Yes, I think it is a very heavily female-dominated industry, whatever the reasons for that may be. And I think it can feel unbalanced when you're in the room if there's two females, one male. And if you co-mediate and there's two females, and I used to do a lot of co-mediating, two females, a male and a female, we have to be conscious of it. But that is our training, that is our role, that is our experiences. We're there to be impartial, we're there to try and help balance the room and create that fairness. So hopefully we manage that. And also, we're not usually there giving our opinions. So what views we may have of, I don't know, how a family is running things, whether we're male, female as the mediator, it shouldn't be influencing the discussions in the room.
Yeah, absolutely. I agree. I second that. I do often get you know, clients, as obviously because being female, I do get men sort of saying, are you going to be on her side? And the answer is absolutely not. We don't take sides. It goes back to one of our core principles, which is we remain impartial. And I will try to reassure clients by explaining to them that this is their process. So if at any point they feel that there is something that's being asked or said and they want to understand why, and they're feeling that it feels slightly not impartial, they need to be able to tell the mediator so that the mediator can either explain themselves or, you know, as I say, perhaps they need to readjust the way that they're positioning a particular thing or statement. Whereas where there are children involved, so a child inclusive mediation, I think at that point it's really good for the mediator to focus on the fact that same as a court, we are there focused on putting together an arrangement that works for the child. So we are focused on those children, and really everything else becomes irrelevant. We are just there to help them. And in terms of the benefits of having that focus on the children, and how generally when we have child inclusive mediation, the feedback that Hazel, you mentioned, that we are able to provide parents, they are then able to make arrangements based off of that. So there are ways that we can manage those concerns, but ultimately I think the industry is crying out for lots more male mediators. I think that would be wonderful. So if anyone's watching, then find out how you can become a mediator on the Family Mediation Council's website.
And actually, this follows on from the Family Mediation Council's website. I've got a question that says, how are you regulated? And is this independent like the SRA for solicitors?
Hazel, did you take? Yeah.
So that's I suppose one of the controversies of mediation. Anybody who trains as a mediator will be trained through a particular body, a regulated body. And following our initial training, we should be moving into what we call an accredited role. We have 3 years to become an accredited mediator and to be compliant with the requirements of the FMC, the Family Mediation Council. And anybody that's in that process of working towards accreditation and is accredited, we work under the umbrella of the FMC, the Family Mediation Council. They have they manage any complaints processes. We have a code of conduct. However, there are some mediators that do work outside that system. There is, I know there's a consideration as to whether there's any way to change that, but it's important when you're looking for a mediator that you find out whether they're registered with the FMC. That's an absolutely key point to know that you are dealing with someone that's in the regulated profession.
Yeah, I think, yeah, just to add to that, I think it's important as well for the public to understand the difference between accredited and trained as well, because often there are mediators that are practicing out there by themselves, and they may not be accredited, and they might be working towards accreditation, and that's fine, and all that information is available on the Family Mediation Council. But it's important that clients know the kind of mediator that they are potentially working with. So if they're a trainee, they might have years of experience, and that's brilliant. But as part of the accreditation process, we do complete a portfolio. We are having to check in with our PPCs, our professional practice consultants. We are gaining that experience of observing lots of different types of cases, which gives us a kind of well-rounded approach in terms of our mediation techniques. So I do think that there needs to be a little bit more work done, especially from the mediation industry, perhaps in terms of educating the public with regards to trained, accredited, what a PPC is, what they do, and all that kind of thing.
And there's another question that's come through as well. Have you witnessed any changes in the social landscape and the political backdrop to the mediation process as family mediators, and have those impacted on the mediation process?
That is good questions. Have you witnessed changes in the social landscape and the political backdrop? I guess the biggest change, well, I don't know if it's a change, but I guess the biggest disappointment at the moment is that in terms of mediation, we know it's one of the sort of least expensive forms of a dispute resolution. And I personally love the fact that I am able to provide mediation through, I work through NFM as well, to clients who are unable to access mediation because of their particular financial situation. So they need support from legal aid. The problem that we're seeing at the moment is that other than services like NFM and a few others, there aren't as many legal aid providers out there. So accessing mediation has become slightly more challenging, and I don't see that changing anytime soon, unfortunately. So services like NFM, who provide that for clients, I think is wonderful, because me as a mediator, then I'm not just seeing private clients that can afford mediation. I'm actually then able to help clients that can't afford mediation, but are the ones that would benefit from child inclusive mediation, for example, because the children are struggling at school, and because it's then impacting their schoolwork, and they're not going to school because of it, and the school's having to get involved, and social services are having to get involved. And so it impacts the wider community. And actually, child inclusive mediation, that feedback where the child then has the voice, it's not just a nice thing to do. It's not a nice thing to do in that sense. It is valuable. We know from research that it actually has huge psychological benefits for the children as they grow up. So tapping into that particular pocket, I think, is really important, and with the lack of legal aid support, that makes it more and more challenging. And I don't know if that fully answers Mark's question, by the way. I don't know if Hazel wants to.
Well, I was thinking of a couple of other things to add in there. There's firstly that court rules changed nearly a year ago, where it's no longer enough to simply certify that you've had a MIAMS and therefore you want to go to court, you don't want to mediate. You are now obliged throughout the court process to explain why you're not using a dispute resolution process and why you are using the court. And so there is a shift in the landscape. I think we're still early days on that. In theory, there could be cost orders. I've heard of local judges adjourning cases saying you shouldn't be here. You need to, I'm not going to see you for another 4 months, 6 months while you go and try a dispute. So a dispute resolution option. So I think there is a shift possibly about to start, but we're early days on that. We also have the ability, accredited mediators have the ability to apply for a voucher from the Ministry of Justice of £500 for the couple towards the cost of mediation if they are going to talk about child arrangements. That is not means tested like legal aid. It is available for anybody. There are a few conditions on it, but almost anybody that needs to talk about child arrangements. While it's not it doesn't necessarily go a long way in the mediation process, that it is available, and we've just had confirmation that there's going to be another year of those voucher schemes. And the other thing I was thinking of that is probably since the advent of the pandemic, technology, we're using technology more in mediation, which enables us to perhaps reach a few more people. It gives that flexibility. Those that perhaps in a distance, different countries, even previously mediation, I'm not saying just since the pandemic it's happening, but it was rare before then that we would be able to mediate over that distance. So there are changes happening, and I think we're still a developing career profession at the moment.
There's a few more questions in here. Another one is, do you have to be a client to complain, or if a mediator is inviting you to a MIAM and it's inappropriate, what would you do to raise this?
So I think in terms of complaint procedures, you do have to be a client of the mediators to then complain about them. So there needs to have actually been an engagement and an initial MIAM. If a mediator is reaching out in an inappropriate way, you can, of course, always raise it to the Family Mediation Council. I think the inappropriate, is vague, so it could be various things. But I think the most important thing is once you're engaged in the process, in that initial MIAM, that initial meeting that clients have, from that point onwards, if there is something that you feel has not been right, then you can, of course, look up the complaints procedure on the FMC website, but also the mediator themselves should have their own version and make it quite clear to the client should they have any concerns that this is the process they follow.
I'm just wondering if that question might be that it's the actual reaching out and the actual invitation to mediation, and it's very rare that we as mediators would know that is inappropriate, because quite often that invitation may go out before we've met with party number one. That change in the court rules that I've just mentioned should mean that everybody has the opportunity to attend a MIAMS. Even if mediation isn't right for you, which is what part of the MIAMS is looking at, it enables you to consider what other options there are out there. So we don't just look at all the different ways you can make mediation flexible in the MIAMS. We look at all the other dispute resolution processes, collaborative law, solicitor negotiation, arbitration, any of those we consider. So I think it would be unusual for a mediator actual invitation to mediation to be considered inappropriate, but I'm sure there will always be exceptions.
Yeah. I think it's also important to note here, Hazel, I don't know about you, but we can only really assess what we're told. So there have been instances where clients will say one thing, and you then do contact the other party based on what they've told you, and the other party says you shouldn't be contacting me, there's a restraining order and he shouldn't be anywhere near me, or she shouldn't be anywhere near me. Now we can't possibly know that, if a client hasn't disclosed that to us in their initial meeting. As much as we will try our best, I say to clients, don't have a magic wand, and I'm not a mind reader. So in terms of what's appropriate, I think we can only go off the information as well that we're being fed by clients.
There's another question here that if a MIAM has deemed mediation unsuitable, do they have to disclose information on why that is? And can they then sort of reapply to try and do child inclusive mediation after some time has passed?
Is that Romina, or shall I?
You can go for that one, Hazel.
So no, the MIAMS meeting is confidential between client one and then when the second one is client two. And so the reasons why mediation might not be proceeding would not be disclosable. That can be to protect the client, because if there are allegations of domestic abuse and we turn around and say, oh, this person said the other person's been abusive, therefore they shouldn't come to mediation, that we've not heard from the other party, they've not had a chance to say. So no, we wouldn't disclose the reasons why mediation is not proceeding. There are particular boxes we tick on the form. It can make it clear if it's someone that's chosen not to mediate, or it can make it clear that we think it's not suitable. And yes, it's always possible to reassess suitability of mediation. I'm not saying 2 weeks later, but 6 months down the line, maybe after something's happened, some change in the relationship, a shift in the relationship, the co-parenting relationship, whatever it may be. Yes, it can always be reassessed to see what might work.
And if you have, there's another question here, if you have one party that is declining mediation, is there anything that can be done to increase any engagement from that party?
So was that with regards to mums declining in particular? Is that the question you're referring to, Katie? Yeah. So I think with that one, I personally have not seen it myself, that it's mums in particular that decline mediation. I don't know if Hazel has a different perspective. What I will say is that the most common thing I hear is the first person will say, look, it's really unlikely that he or she will come. They just don't want mediation. Like, you're wasting your time. And the reality is that 9 times out of 10, once we try and speak to them or engage with them, they actually want to hear about mediation, and they do come to that initial meeting. So I think the key difference is they don't want to hear it from the other party, But when it's someone who, once we explain that we're impartial and how mediation works, then they're always willing generally to listen. So I don't think there's a particular, not from what I'm seeing of mums declining as such. And I definitely think in the last 18 months, because of the rules, being changed, there is definitely more of a focus on mediation. And so people know that they need to at least hear about it, even if they don't want to necessarily engage in it. So I feel it's quite a positive process that people are willing to hear about right now. I don't, Hazel, if your perspective's slightly different on that.
No, I think once we reach out, sometimes when it's not the other parent or ex-partner, once we reach out, the professional, it gives it a certain gravity and seriousness that will often bring the other person to contact us. I also think, though, that you will always get those that do ignore that invitation to mediation or say, I'm not coming, or whatever it may be. And there is a limit to what we can do as mediators because of it being that voluntary process. But this is where, again, if you have your MyAMs, we can signpost you to what you could do next. Quite often that might be to have that chat with the solicitor, so a solicitor can explain to the other person the consequences of not engaging with mediation, i.e. if there were a court application, that cost orders could potentially be considered if someone's refusing unreasonably to consider a dispute resolution process. So us as mediators, I think it's difficult for us to put a great deal of pressure on because of the impartiality, but there are other sources out there that can help you to try and get the other person engaging.
I think we've probably only got time for one more question now, but we've got one here that says, do you have to just choose the one type of mediation at the beginning, or can that change throughout the process?
No, it can change. So, I mean, generally at the initial MyAM, we are trying to assess what needs to be resolved. So I think that commonly we'll have clients that come to that meeting and, they are separating or divorcing, and they've decided that, children arrangements is a real struggle. And so their focus for coming to that particular meeting is they want to reinstate contact, or they need to sort it out, and it's really difficult. So we know that that is the primary concern. But as a mediator, I'll always be asking what else needs to be resolved, what else is outstanding. Do you own property together? Especially if they're married, we talk about pensions. So we just provide a little bit of information and just get them thinking that this is not just about that one thing there that they're struggling with, albeit the most important thing if it's parents and children, but there are all these other avenues as well. So, and what I often say to clients is, it might be that we start talking about finances and then we'll talk about children, or vice versa. And we mention obviously the voucher scheme that's available when we are talking about children arrangements. So no, it doesn't rule them out. They can come back to mediation. They can do mediation on one thing and then try it out. Especially I've got parents that will figure out their children arrangements for a while and then come back and say, we're ready now to look at how we're going to divide up the assets. So that's going back to our presentation about the flexibility of mediation. I think that's why it's become more and more common, because it just allows people to figure out what they're doing in one of the most stressful times in their lives, prioritize the thing that's upsetting them most, and in this example it would be children arrangements, and then come back and talk about finances.
And they can talk about it in one way for the children. So you might just have them and the mediator, and if they feel that they needed to have, I don't know, solicitors involved, they could have solicitors involved, or if you had a family consultant in the first part. And so again, that's the flexibility of mediation, is it can always be adapted as you go through the process to meet the next particular need. And as Romina said, we would help them to identify what needs to be looked at and how best to deal with that.
Well, I think we're coming up to the hour mark now. Thank you both so much for your time, and thank you everyone for joining today. It's been brilliant. Thank you so much.
Yeah, okay.